Thank you, Mr. Cranmer. Good morning, everyone. Okay, that's better than yesterday. It was a deafening silence yesterday. So good morning. Welcome to the Michigan Court of Appeals. It's my privilege to serve today with Judges Wallace and Judge Levincy. I apologize, Judge. Again, by the time I retire, and it'll be at the most 8.5 years from now. I'll get it right. So at any rate, it's my privilege to be here today with these two fine judicial officers. Thank you for appearing for oral argument. This is panel 6. It's day 2 of our session. We have had a chance to review all of your pleadings, all your briefs. We thank you for them. They're very helpful and informative. We'll have questions for you, I'm sure. Today is the fourth day Judge Levinski has served on our court. We thank Governor Whitmer for appointing him, just as we thank Governor Whitmer for appointing Judge Wallace, as well as the other fine judges that have joined our court since Governor Whitmer has taken office. Judge Levinski is coming from the U.S. Attorney's Office in the great city of Detroit, where I grew up, 16-year veteran of that office, University of Michigan law grad, Ohio Wesleyan undergrad, Honigman lawyer, so we won't hold that against him. But no, we have a lot of good Honigman lawyers over the years on our court, including now Judge Schwartzel. But just yesterday added so much value to our deliberations and our consideration of your cases, as I'm sure he will in all the cases. But we're great and glad to have you. Thank you for being here. There are cases that have child victims, and there's some sexual assault cases. If those are what you're here on, if you could refer to complaining witnesses or victims as by their initials, that would be appreciated. And I think that's about all I've got on the stuff we need to talk about beforehand. Anything else you need to address, Judge Wallace?
No, sir.
All right, Judge.
Thank you for your kind words. Happy to be here.
All right, great. Okay, first case is People versus Roderick Smith. Case number 13, both counsel are appearing remotely. Mr. Babcock on behalf of the plaintiff appellee and Mr. Skinner on behalf of the defendant appellant. So through the magic of IT, we should see them soon.
Good
All
morning,
right.
I'm Michael Skinner on behalf of Mr. Smith.
Morning. Mr. Skinner, you may proceed when it's convenient.
Thank you, Your Honors. In looking over the briefs, I don't have anything to add to my brief, but I'd be happy to answer any questions that you have.
Okay. Judge Wallace?
No questions. Thank you.
Judge? Questions?
Give me 1 second, please.
Yep, please. I do have one question while Judge Levincy is looking at his notes. Is the fact, Mr. Skinner, that the case was a Cobb's agreement, is of that any import to how we analyze the questions in this matter?
I believe the Cobb's agreement, unless I'm off, was just to the low end of the guidelines, to the bottom of the guidelines. So this will change the guidelines. So no, it doesn't really affect it. If the guidelines are going to change, it's going to change that Cobb's agreement too.
Okay, so the manner in which the agreement was entered into then was there wasn't and the guidelines are A to B and it's a Cobb's agreement and we're going to be within A to B. It was bottom of the guidelines is your Cobb's. You were free to you or your trial court counterpart was free to seek whatever relief they could in the lowering of the guidelines.
Correct. And in fact, Your Honor, the motion or the brief that I filed was really just continuing a pro se motion that the defendant filed himself, arguing OV12 and PRV7. The trial judge granted relief on OV12 and at that time lowered the sentence by 1 month. If this appeal were to succeed, his guidelines would go from that low end of a 9 to a low end of a 7, and the judge hasn't said formally, but she has made it pretty clear that she would drop it down again, I think.
Okay, thank you. Judge?
I do have a question. Thank you for the time because I kind of expected you to have a little more argument so I could get and collect
Sorry,
my
Your
Way
Honor.
to, way to throw the new guy, Mr.
I
Skinner.
appreciate it, keeping me on my toes. So reading the text of PRV 7, it says it applies if the offender has one subsequent or concurrent felony conviction. All of the briefing has focused understandably on the concurrent felony conviction verbiage. So if you're not prepared for this, I understand. What about the idea that the conviction for the 2021 conduct was registered subsequent to the conviction, the conduct underlying the 2023 conviction?
Yes, Your Honor. So, Your Honor's right. I probably should have addressed that. I think, though, that if you look at the language of PRV 7, what it says is, and actually I think I have it here, it's if the conviction was entered, I apologize, one second. The sentence, after the commission of the sentencing offense and is unrelated to the conduct from which the sentencing offense arose. Now, obviously, there's a time gap here, but I would suggest that the entire prosecutorial theory is that Mr. Smith was dealing drugs. The charges that were dropped in the 23 case, which is the case that we're on, were drug charges. The gun charges remained. The 21 case was a possession with intent to deliver cocaine. So I would suggest that they are related, they are related charges in that it is a pattern of conduct, and that the fact that they are not unrelated, that they are related, means that they can't be scored.
Well, that feels to conflict with the argument in your brief that they're unrelated. I mean, if it's, I don't know how I feel like I'm opening up unintentionally a conflict that didn't previously exist. But I mean, if they're concurrent and they're happening around the same time, and they're related. I thought your argument in your brief was essentially one was a drug offense. The 2 years later, one was a gun offense. They were 2 years apart. One was drugs, one was guns. They're not concurrent. So the trial court shouldn't have scored PRV 7.
Part of the problem, I think, is probably that when discussing this, and it wasn't even entirely clear to me in the transcript. So there were drop charges, and the question is, well, what do we do with those charges? Can those support the scoring?
Take that apart, though. The question really isn't about that right now.
Okay.
The question is, there's the 2021 conduct, then there's the 2023 conduct. Then he pleads guilty, my understanding is, to the 2023 conduct, and then on the very same day pleads guilty to the 2021 conduct in a separate case. Am I right?
Correct.
Okay. So the conviction for the 2021 conduct occurred subsequent to the 2023 conduct, correct?
Correct.
And again, I understand you didn't brief any of that, but under that fact pattern, would PRV 7 apply for 10 points because he does have one subsequent conviction, which is the conviction for the 2021 conduct happened subsequent to his 2023 conduct? Or is that wrong? And the other answer is essentially, well, the trial court never evaluated it. We didn't brief it. I did a little research on it. Frankly, I couldn't find any authoritative case law applying it in that context. So I acknowledged at the beginning, I'm asking you something that wasn't briefed. And so if you don't have a full way of looking at it, that's okay. I just wanted to get your reaction to that kind of fact pattern and whether the PRV would apply under this sort of subsequent conviction theory rather than concurrent.
I'll say this. I'm continuing the argument of my client. The PRV scoring, I mean, I don't want to be repetitive, and I hope I can answer this, is that the language of the PRV says it has to be unrelated. I believe it is related based on the prosecutor's theory of he's a drug dealer, he's dealing drugs, this is a pattern of drug convictions. As to the concurrent aspect to it, on those, they dismissed those charges. They dismissed the other charges in the 23 case. And the concurrency for those is more time related. And because they dismissed those cannot be used. I don't know if that clears it up or not.
Okay, I understand.
I think where the judge's thought comes from is the fact that if you look at the statute 777.57(2)(a), it refers to a subsequent felony conviction. It refers to a conviction, not a subsequent offense. And he was convicted that day, so I think that's what the judge is getting at. The legislature could have chosen the word offense instead of conviction, but it didn't.
I agree, Your Honor. It's just again, I'm looking at it. So it says a conviction arising from the same course of conduct as the sentencing offense. And I guess, again, to continue the argument, it's because it's arising out of the same course of conduct, it does not become a subsequent offense. I agree that the timing is such that, let's take a different hypothetical. If he had, an unrelated armed robbery of a 7-Eleven or a CSC conviction or some such, that would be scoreable because yes, he commits the offense and he commits the offense in this case and gets a subsequent conviction for unrelated conduct. My argument is this is related conduct. Therefore, it doesn't get scored.
Thanks.
Okay. Judge Levincy?
Nothing further.
Well, okay. Thank you.
Thank
Mr.
you.
Skinner, you have enough time for rebuttal if you'd like. Mr. Babcock?
Yes, Your Honor. May it please the court, Russell Babcock on behalf of the people. I mean, I think the difficulty that exists here for the defense is, of course, the appellate counsel inherited the argument that was raised by his client at the trial court level. And to answer the court's questions here today, which really were not even raised by the defendant at the trial court level, the PRV 7 was scored at 10 points due to the fact that he had a concurrent felony conviction for delivering manufactured controlled substance less than 50 grams in case number 21-048352FH, which was noted in the PSI and which the trial court also noted on the record in the November 4, 2026 transcript, page 16 at lines 22 to 25. So, and the court is correct. The statute refers to convictions, not offenses. So it remains the people's position that the 10 points was properly scored. Now, the defendant at the trial court level kept arguing hearsay and why he felt hearsay shouldn't be considered. And obviously, we have briefed that issue on appeal further. And for those reasons, unless your honors have any questions, we just simply feel that in this case, the record was sufficiently developed that he was properly scored at 10 points. I know that defense counsel has made some additional arguments on appeal, but when you read the transcript of the hearing at the trial court level, he was focusing on this hearsay issue, which may have been applicable to the one OV that was ultimately ruled in his favor, but really had nothing to do with what was going on with the PRV 7. So that's our position. Your Honor, we'd ask that the court affirm the trial court's rulings.
Ms. Walls?
I take issue, I guess, a little bit by saying that it's the defendant who's changing his argument because it was the trial court that assessed this PRV 7 based on the concurrent conviction. So of course, that's what the defendant was, so to say the defendant is, didn't make the argument about subsequent to is a little unfair because the trial court relied on the concurrent, right? I mean, that's.
And again, I recognize, in all fairness to the defendant, he's not an attorney, and he was trying his best, I think, to present an argument. But my point is that, and I will acknowledge the fact he was not an attorney. On the other hand, I do believe, based upon what I just explained to the court a few minutes ago, that the PRV 7 was properly scored at 10 points.
But I guess my question is the trial court correct in scoring it based on the concurrent conviction provision? Because that's what the trial court did.
That it was correct, Your Honor. And as the court has been.
How are convictions 2 years based on conduct 2 years apart concurrent?
Because it's based on, as your colleague had indicated on the record, the statute bases on conviction, subsequent or concurrent conviction, not offense. So even though it was from a 2021 case, the conviction was in fact concurrent and or subsequent. My recollection of the PSI was concurrent, but it could have been, even if it was consecutive. Under PRV 7, it was countable and was 10 points.
So because they were entered on the same day?
On the same day, yeah. The convictions were, which is, again, what the court is, pursuant to the statute, what the court is supposed to look at.
Okay. Okay, I don't have any further questions. Thank you.
All right, Mr. Skinner, Mr. Babcock, thank you both. It's always a privilege to have you in front of us. You always give us thoughtful, well-prepared arguments and briefs. So we appreciate it. This matter will be submitted. Thank you.
Thank you.
Thank you, Your Honors.
Case number 14, the court calls People of the State of Michigan versus Ivory Elijah Polk, case 375-102. Mr. Babcock continues to be with us. I've just been advised by Mr. Cranmer, our security director, that Attorney Young has waived oral argument at this point. Is that correct, Dan? Okay, thank you. Pardon me? Oh, I'm sorry to hear that. She's a very capable advocate. We wish her well, and we're grateful for her appearance on behalf of her clients in so many cases. Mr. Babcock, anything you want to share with the court?
Your Honor, other than I'll make my appearance, Russell Babcock on behalf of the people. Unless Your Honors have any questions, really, we'd rest on our briefs as well.
Judge Wallace?
No questions, Judge. Thank you.
Judge Levincy? My wife says to me geez, for a guy who gets elected for a living, you really don't pronounce names very well. And so
My kids started calling me Judge Andy.
Judge Andy.
But
Okay. Can I do that?
No.
Okay.
Your Honors, don't feel bad. I'm admittedly very horrible with names as well.
I have special privileges
Judge L.
as my children. I have no questions. Thank you.
Okay. All right. And for the benefit of Mr. Polk, this should not take away this. We understand this is a very serious case. We're very grateful for the thoughtful testimony. It was an enormously serious case for the parties, the victim, the defendant, and we've talked about the case among ourselves. I said yesterday in preparing for today's oral argument, it's been quite some time since I've had so many discussions with other panel members beforehand, and this is one of the cases we talked about. So we understand it's important. We wish Ms. Young good health quickly, and we'll consider all the arguments made. This matter is submitted. Thank you.
Thank you, Your Honor.
You're welcome. Case number 15 is the People of the State of Michigan versus Summer Ray Moommi, and I'm probably mispronouncing that name incorrectly. The plaintiff appellant is not endorsed for oral argument. but Attorney Janice Dager-Margosian, another capable advocate who we often see is endorsed, and we look forward to her comments. You're on mute,
Unmute.
ma'am.
Okay, can you
You're
hear
good.
me now?
Yes, ma'am.
Okay, thank you very much, Your Honors. Good morning. I'm Janice Dager-Margosian for Ms. Mumi, who also goes by Ms. Gruber, her married name. The prosecutor didn't answer and isn't present today. There's no response filed on the part of the prosecution. I am prepared to rest on my brief unless the court has any questions.
All right, let me check my notes and check with my colleagues. Judge Wallace,
1 second.
pardon?
1 second.
Okay, yeah, we're all gonna, yesterday's arguments, counsel, no one was quite as speedy as any of the lawyers today. So we're kind of used to about 15 minutes to get ready for the next case. So give us each a moment, please.
Sure.
Thank you.
I don't have any questions.
Okay.
I don't have any questions. Thank you.
Were you counsel in Goulder?
Goulder?
Yeah.
Goulder, was I the lawyer? Yes.
Yes. Yeah.
Huh.
You've had a lot of these cases, so it's been interesting reading your brief. So very thoughtfully presented in this and all the cases that have been before the court. So, okay. I don't have any other questions. And neither do the judges. So counsel, thank you again for taking these assignments. It's important for our sisters and brothers who have criminal cases to have good defense representation, and you and Sato and all of our defense attorneys do a very capable job. So thank you.
Thank you.
Thank you, Your Honor.
All right, the matter will be submitted. Thank you. All right. Call the next case is People of the State of Michigan versus Jesse Aline Gourhouse, case 375798. Mr. Catalino is endorsed on behalf of defendant appellant. Oh, my friend, I am right with you. These two young guys, they move around a lot faster than I do. So especially Judge Andy. Oh, sorry. I'm sorry. I'll stop doing that.
I'll note that my parents hate the nickname Andy, yet ran the risk of that when they named me. So I guess I'll just take it. So.
And we met your dad yesterday. He doesn't seem like he'd do something
Very risky.
that mean spirited. Well, I have 5 older sisters and a younger brother, and my entire life for my sisters and my cousins, it's Jimmy. So,
Okay.
and when people who know me from the Navy or the judiciary hear my sister, they're Jimmy. I've never thought of you as a Jimmy. So anyway, all right. We
And
digress.
I have 4 children, none of whom have any nicknames.
Oh, no kidding.
Yes,
Oh,
they all
man,
go
you should
by
write a
their
book
full
on
given
naming
name.
children. And so all of our kids have nicknames. All right,
Even
counsel,
as adults.
thanks for taking the case as always. Appreciate it. Happy to listen to whatever you'd like to share.
Your Honor, I would just say that we've briefed this. I think the prosecution has filed a response. I think it's going to come down to, quite frankly, the court's interpretation of whether this was a continuous event or separate events. I think each side has laid out their arguments. I have really nothing to add to what we've presented in our brief. I would submit that they are not a continuous act, that they're separate and distinct, especially given the argument of the government during his summations and the area.
On that point then, I mean, should on this fact pattern, your client been charged with multiple separate domestic violence charges?
It was one information. So it wasn't, I'm sorry.
I know, but like, if you think they're separate, right? I mean, would it have been better for your client to be facing 3 separate domestic violence charges?
I don't know that it would have been better. I think it would have required that the prosecution select its how it cared to proceed. The fact that there may have been 3 separate distinct offenses puts him certainly at risk of a conviction on any one of the three, if indeed the proofs met the standard. But that was a prosecutorial decision, and it doesn't change our position on the error that we assert.
Well, I guess the reason I ask is then you're saying then either the prosecutor's decision had to be multiple separate charges, or you need a specific unanimity instruction.
Yes.
Okay. On page 13 of your brief, you said that the law, quote, permitted a specific unanimity instruction. Is your position that it permitted it or that it required it?
Well, I did use the term permitted, but if indeed it was separate distinct acts, then it was required.
Okay.
Where do you fall on the waiver versus forfeiture issue on the instructions? Because my recollection is that counsel for the accused at the trial court level said that they were okay with all of the instructions.
Well, I think it was compounded, the error was compounded by the fact that trial counsel had objected to the prosecutor's misstatement of the law. Then
there was a curative instruction.
Well,
Right.
It was cured, and our position is, Your Honor, it was cured only as to the felonious assault. There was no curative instruction for the domestic violence. It was our reading, my reading of the curative instruction focused only on the felonious assault, and the trial court did not give a curative instruction on the domestic.
Okay. And so how does that dovetail into the waiver forfeiture issue?
Well, I believe that the objection was preserved because
I
there was
see.
an overall, I don't believe it was waived. I believe there was an overall objection. The trial court ruled. Once the trial court made its ruling and determined that it would not give a curative instruction, or there was no request for a curative instruction specific in the jury instructions, that the trial court assumed that it had been corrected by the curative instruction during the course of trial.
Okay. All right. Judge Wallace?
No questions. Thank you.
No additional questions. Thank you.
All right, great. Thank you. The matter will be submitted. Next case also has Mr. Catalino on it. It's case 17. It is People of the State of Michigan versus Karen DeLynn Brown. It is our case 374865. Ms. McMurdy represents plaintiff appellee. Mr. Catalino represents defendant appellant.
Good morning again, Your Honors.
Good morning again.
As the court is well aware from having read our brief on this and reviewed the case, we raised basically the same issue as I did in my preceding case. It's our position that a unanimity instruction should have been given at the trial court level, that the counsel's failure to ask for it constituted ineffective assistance of counsel if indeed one was required. We'll stand on our brief unless the court has any questions.
All right, thank you. Judge Wallace?
No question.
A couple of questions about the butcher knife.
About the what? I'm sorry. Your
The
Honor.
butcher knife.
Okay.
Essentially, which I think is the source of one of the sources of your argument regarding the need for a specific unanimity instruction. Would you agree that the charging document did not reference the butcher knife?
Yes.
Okay. And then, so evidence of that was no one moved to exclude that, right, as potentially irrelevant or?
Correct.
Okay. All right. Thank you for the clarification. No further questions.
Okay. Again, thank you. Anything else you want to share before we hear from the prosecutor? Okay, you have time for rebuttal. Thank you. All right, Ms. McMurtry.
Good morning.
Morning.
I almost feel compelled to make some argument because it's gone so quickly this morning. So
It's okay. Yesterday, we were hearing arguments until 3:45. So it was compelling and interesting. And there were, as our sister and brother counsel from the public defender's office know, there's a lot of litigation on the Sex Offenders Registry Act. We had 2 cases, and this court had issued a published opinion last week, and then the Supreme Court issued a published opinion 2 days after the Court of Appeals issued one. And we had a couple of cases that had matters from 1996 to 2006. It was so that, and then we had continuing opportunities of service addressing the Raffaelli cases and forfeiture of tax proceeds. So those cases took a long time, and there were a lot of other interesting cases too. So don't feel bad that it's going quicker today.
Okay. Well, the previous case did have the similar issues about the waiver and the unanimity instruction. So if there were any existing questions on those, I'd welcome them. If not, I would rest on our brief.
In the previous case, number 16, that we talked with Mr. Catalino about, there was some question of whether or not trial defense counsel had waived by agreement on the jury. That I don't think, is there any indication that there was any waiver in this case?
Yes. Same situation. In this case, the defense counsel signed off on the jury instructions on page 4 of the transcript dated 8/1/2024, and then again on page 69 of the transcript. So 2 times they waived and signed off and physically signed the instructions. They did have one cautionary instruction that they challenged, but it was not related to the unanimity instruction.
Okay, give me just a second. You're in the Berrien County PA's office.
Yes, sorry. Julie
Okay.
McMurtry, Assistant Prosecuting Attorney in Berrien County Prosecutor's Office.
So I have a question about the trial practice in that circuit. When a petite jury is being charged, how does how are the jury instructions presented to the jury? Meaning, are they read? Are they handed to them in writing, or both?
In this transcript, the judge makes a point of saying that she's required to read the instructions on the record. That's at page 124 of the transcript, and she does in fact read those. They are also provided written copies to review, but then I believe that those may be turned in.
Turned in when?
Before they go back to deliberations, I believe. It was in the transcripts.
The reason I say that, I ask that question is I had the privilege of serving as a trial judge for 12 years in Michigan and 5 years in the Department of the Navy. And in all of my civil cases and all of my criminal cases, 100% of them, from day one to day whatever, every single jury had a complete, and juror had a complete set of printed instructions that I was reading to them. And every single juror took them back in the jury room with them. And in 230 plus jury trials, I don't remember, well, I know I never got a case back on jury instructions. And it initially takes a lot of time for the lawyers in the trial court, but once the trial court has them in their system, it takes less than an hour per case to finalize them every time. And I analogize it to, we ask jurors to decide a case. It'd be like going to my kids and saying, okay, we got a 65 Jeep up at the cabin. Here's what you need to do to rebuild the engine. I'm going to read you the Chilton's manual on rebuilding engines and say, okay, good luck. You know,
So just to clarify, the judge did provide those, page 135 of the transcript. When you go to the jury room to deliberate, you may take full instructions. If you want to look at any of the reference documents or exhibits that have been admitted, just ask for them. And that's lines 21 to
Okay,
24.
good.
So I
that's what
misspoke when I said I
just,
wasn't
you know,
sure.
I don't presume to speak for the entire judiciary of Michigan, or I barely presume to speak for myself, but it seemed to be a helpful practice. So at any rate. Okay, I don't have any questions. Judge Wallace? Judge Liebenstein? Okay, thank you, counsel. Mr.
Thank you so
Catalino,
much.
any follow-up? Okay, well, I'm glad you didn't hedge your bets. Oh,
I
it's
do.
Redford. It's going to take till 2:30 to get to it.
I do have a question.
Okay.
I have a question for Mr. Catalino.
Judge Wallace.
My
has a
question for you is, considering the fact that your client claimed throughout these proceedings that she had no weapon of any kind whatsoever. Why wouldn't we determine that the decision not to request that special instruction here was a matter of strategy?
Well, I think that the trial counsel ought to remain. Argue that so as a matter of trial strategy, that she did not have what they found that she did, and it does not change the position that we should be using in the instruction.
Okay, thank you.
Okay, thank you. That matter is submitted. Next case is case number 18, People of the State of Michigan versus Andrew J. Boyle Jr. This is case 371301. Catherine Wendt as plaintiff appellant's counsel. Appellee's counsel is not endorsed, and defendant appellant previously endorsed for Brett DeGroff is now oral argument by attorney Nicole Jasmine.
Good morning, Your Honors.
Morning.
Jasmine Zabo from the State Appellate Defender Office on behalf of.
Could you state your name again, please?
Yeah, Jasmine Zabo,
Oh.
Zabo.
Okay.
We were
That's-
having some technical.
It said, what I received was something that said Nicole Jasmine, so not sure how, pardon?
It's my middle name.
Oh, okay.
So
Like I'm James Robert Redford. People call me Mr. Robert. I answer to anything, so, yeah.
me too.
Okay, all
Thank you,
right.
Your Honor.
Please proceed. Have you argued before us?
Not in front of you all. I've done one other Court of Appeals argument.
Okay, well, welcome. What courthouse were you in for that one?
Detroit in March.
All right, good. How do you like it so far? Good.
Definitely still a little nervous, but
Well,
okay,
if you're not,
prepared.
if you're not nervous and you're either a trial lawyer or an appellate lawyer and you're getting ready to present your summation, then you're in the wrong line of work because it means you're not worried enough about it. So don't be afraid to embrace the nervousness. That means that you care about your client, means you care about your profession, means you're going to do a good job. So have at it.
Thank
And
you.
we'll try not, I'll try to keep Judge L from yelling at you. So,
I welcome any of your questions. When Mr. Boyle was acquitted of assault with intent to commit criminal sexual conduct, the presumption of innocence remains intact. In other words, the jury's verdict foreclosed any question of whether Mr. Boyle had a criminal sexual intent in committing the other two offenses. That is true under Beck and its progeny. Here, the trial court violated Beck, where its primary focus in articulating its sentencing rationale was not on Mr. Boyle's actual convictions of unlawful imprisonment and assault with a dangerous weapon, but instead on Mr. Boyle's prior convictions for criminal sexual conduct and the similarities between those prior convictions and the conduct for the sentencing offense. When to the extent there's any ambiguity remaining about what the trial court's focus was, this court has only to look to the rest of the sentencing court statements during sentencing. And this court should look only to the sentencing transcript, the sentencing statements, and not to the trial court statements in the motion hearing after that predicated argument here today.
why?
Why? Sorry.
Other statements are in the record. Why
Yes, Your
wouldn't
Honor.
we consider those as well?
Your Honor, when in this case, we're assessing to what extent the trial court was relying on acquitted conduct, that is, here, the assault with intent to commit criminal sexual conduct.
Hmm.
And in looking at the sentencing remarks, the focus is on those prior convictions and the similarities. The sentencing court is talking about that Miss Omar was a woman, that she was alone or in a alone type situation. In the motion hearing, what we have is,
Who asked for the motion hearing?
yes, is it
Who asked for that?
Mr. Boyle, Your Honor.
Okay, so the defendant said, I want a hearing. And either the trial court or this court said, okay, you get one. And then the trial court says, no, I didn't mean that. This is what I meant. Right?
Yes.
Oh,
You're-
okay. Well, why? Why that in conjunction with your client did have these prior criminal record, criminal convictions.
Your
There
Honor,
was a victimization in these prior criminal convictions, right?
yes, Your Honor. So two things there. So as to the motion hearing, I guess what I should say is that the motion hearing should be given less weight. We don't want to create a situation where trial courts are able to evade appellate review and shield themselves from Beck after the fact by re-articulating or repurposing the statements.
Then
they
why
made
does
at
your office
sentencing.
continually ask for hearings if we're told to give them less weight? We're to give a less credibility to a constitutionally elected or appointed and sworn serving judge because it's a hearing that you asked for? I don't get that.
The only way for Mr. Boyle to receive relief and to advocate on his behalf was to file the motion to correct invalid sentence in the trial court. That is where he was given the opportunity to challenge the statements made at sentencing. We're concerned with the statements made at sentencing here, and the concern was to what extent the trial court relied on those statements in imposing its sentence. If we look less to the statements made during sentencing and more to the after the fact explanation by the trial court, then we run the risk
How many
of,
sentencings did Judge Noto have to impose the day he imposed the sentence in your client's case?
I believe it was Judge Rossi in this case, Your Honor.
No, Judge Noto was the trial judge.
And I'm not sure how many sentences Judge Rossi had to impose. What I do know is.
What I do know in 17th Circuit, which is where I served and where these judges served, is each sentencing day, each sentencing judicial officer would have somewhere between, 5 and 25 felony sentences that they had the duty to impose. I don't know if that's the case here, but my point in that is in 2 hours, you're sentencing 20 citizens or defendants. Some might not have been citizens, but you're saying 20 cases. They're all serious, but the trial court has to get through them. And then there's another hearing post-trial, post-sentencing that's asked for by the defendant. And then the judge has more time to spend on that individual hearing, I would think. And I'm for the reviewing panel's ability, the 7 justices of the Supreme Court, whom I have tremendous respect for. I'm not imposing my experience onto my review of this case. So if they're troubled by my comments, it's not affecting the impact. But we have a situation where now the court is completely focused on this one case. I don't understand why we should give less. You're specifically saying do not give as much weight to the statements of a judicial officer at an evidentiary hearing than you did at the initial hearing. And I think that's what you're asking us to do, right?
Yes, I understand.
Is
Your
that what's
Honor's-
being asked to happen?
Yes, if
Okay.
it's between the statements, the articulation of the sentencing statements at the motion hearing more than a year after sentencing. Yes, I certainly believe the trial court reviewed the record and reviewed his own statements, but this is happening a year later. When we're assessing the sentencing rationale that was relied upon and whether that was predicated on constitutionally permissible considerations, we want to look to the actual statements made by the sentencing court. And we know, I would point to the sentencing court's rationale in Beck that the Michigan Supreme Court talked about. There are some similarities.
Well, in Betts,
in
the
Beck.
sentencing judge said, basically, I think you killed the guy. And he had been acquitted of second-degree murder. In this case, there isn't anything remotely close to that is said by the sentencing court.
In fact, defense counsel was the one that raised this issue. The way this whole thing started is the court simply said, do you have any objection or proposed changes to the PSIR? And defense counsel then said that she wanted to object to the category of mental health because it said he had been diagnosed with being sexually preoccupied. And she argued that that is not a diagnosis contained in the current DSM. That's how this all started. The judge didn't even bring it up. It was your client's attorney that brought this up.
Your Honor, I would actually separate those out. I think that it's really important how the sentencing court responded to that objection to the PSIR. The court did overrule the objection and indicated before either party had made their sentencing argument that it was the sentencing court's intention to direct sex offender treatment, even though Mr. Boyle had already completed sex offender treatment during his previous incarceration. And
Why is it improper for a judge who has been given the entire record, who thinks that someone can benefit from a specific body of counseling that's available in the Department of Corrections? How is it the law of Michigan is now that it is reversible error for a judge who has presided over a case to say, and I think when you're in DOC, you ought to get sex offender counseling. That becomes reversible error. That's what the law is in Michigan now.
no, Your Honor, that is not itself the reversible error. It's simply a salient factor, something that this court can look to when trying to decipher if, in fact, the sentencing court's
So
intention.
if a judge is so conscientious and so concerned about the citizens, he has the responsibility, the heavy, weighty, constitutional and societal responsibility to impose a prison sentence. If a judge says, I think you should get counseling or sex offender treatment, knowing that they have multiple sex offender convictions in the past, that is going to be construed as the judge acting in an ultra vires capacity. That's what the Sato's position is.
Your Honor,
Yes or no?
I don't think it's as simple as that, Your Honor.
How is it not that simple?
What our argument is that, the statements, and turning back to, I'm going to answer your question, but just bringing in my answer to Judge Wallace's question. There was that objection to the PSAR that happened. The parties each made their sentencing arguments. And then once the court starts to articulate its sentencing rationale, that's where we get this comparison between the prior convictions and immediately a discussion of the conduct in the sentencing offense. And so we have what Mr. Boyle is characterizing as, this.
We're actually well beyond the amount of time you have. I'm sorry, I haven't been keeping, you started at 10:28 and it's 10:48 is my understanding. I'd like you to why don't you take a few more minutes to finish, because when you don't have opposing counsel, you have 5 minutes.
I see.
So it's my oversight. I dropped the ball on that and I've been ranting too much. So, and I've been hogging the mic. So why don't you answer Judge Wallace's questions and let's go on to whatever you have next. Okay.
Okay. So I just to wrap that up, the PSIR's objection that the court is the one who inserted that that he was going to direct treatment for sex offense. And if we're concerned about whether there is this reliance on acquitted conduct or not, and that we find this court feels that there's some ambiguity, the fact that there is this focus on treatment, in addition, it's just a supporting factor. It's not dispositive, it's a supporting factor.
I'm troubled if we start saying that this is something we're going to consider, then judges who think somebody needs treatment and DOC is going to maybe look at the record that somebody who needs treatment isn't going to get it. And I don't know if he needs treatment.
I think when you were speaking a minute ago, you started to say after the court articulated its rationale, it then compared the prior conduct to what happened here. And I think that maybe is another issue though, which isn't that really what happened here? In other words, what the judge is focused on is not the acquitted conduct. Judges are focused on the prior conduct, considering the fact that he's supposed to consider the entire, record in front of him.
The judge can certainly consider the prior convictions in the sentencing guidelines. We're absolutely not saying that he cannot. The concern here is that when those statements were made during sentencing, the focus was not in the context of the sentencing guidelines. It was in this analog, and an analog that was apparent in the Beck trial court. The sentencing judge there talked about the previous homicide conviction and then turned to the offense conduct.
No, it was homicide acquittal. Oh,
There was a previous homicide conviction.
That's right. You're right.
and
I forgot it. I forgot that fact.
problem.
That was decided, gosh,
And the sentencing
6 years
court,
ago.
they talked about the previous homicide conviction and then immediately talked about the instant conduct. And though that judge made express findings, the Beck judge obviously
Yeah,
wasn't bound by Beck.
didn't the sentencing judge say, I know they acquitted you, but I think you did it, or words to that effect?
Yeah, he found it by a preponderance of the evidence, and thus we had
I mean,
the decision.
I don't think we have that, do we?
We don't, but we don't need that. That's, and I guess I'll conclude with this, Your Honors. If trial courts are able to rely on acquitted conduct and avoid resentencing through disclaimers and rearticulation, here we have disclaimers both during the sentencing statement, during the sentencing remarks, and especially in the motion hearing, that it was actually about the sentencing guidelines, that he would have departed if he had been convicted of this assault with criminal sexual conduct. And kind of recharacterizing what actually happened during sentencing. If trial courts are able to rely on acquitted conduct and avoid resentencing through disclaimers and rearticulation, and then Beck has no force of law, and the constitutional guarantee that the presumption of innocence is preserved by a jury acquittal will continue to be violated.
Why don't you sum up the arguments, because we're, wait, that's it? Sorry.
This court should hold that the sentencing, this court should hold the sentencing court violated Beck and Mr. Boyle's case and remand his case for resentencing.
Okay.
Thank you.
You did a very fine job.
Thank you.
Your client should be very appreciative of your excellent advocacy. We appreciate it. Thank you. This matter will be submitted. All right. Okay, that's number 19. We have just a moment before I call the next case. All right, case number 20 is I'm sorry. Case number 19 is People versus Keith Young. Ms. Wendt on behalf of plaintiff appellant, Mr. Wright on behalf of defendant appellant. Mr. Wright, how are you, sir?
Well, how are you, Your Honor?
Good, nice to see you. Counsel, okay, you may proceed.
May it please the court, Ali Wright from the State Appellate Defender Office on behalf of Mr. Keith Young. I was going to predominantly focus my argument on the first issue raised in the brief, but if the court has questions on any of the other issues, I'd be happy to answer them. But I do think the question.
Let me just write down. I didn't write down when we started on the last one, and I didn't not doing my job as PJ. So hold on a moment, please. Sorry. Yeah. Okay, please proceed.
Thank you. The question Mr. Keith Young's case presents is when a judge and a prosecutor provide a defendant with a low, if not inaccurate, but a low estimate of his sentencing exposure moments before he decides to take his case to trial, does trial counsel have a duty to make sure his client understands just that those are that the information he received from those trusted authorities is at best an estimate and at the very worst inaccurate, and that his exposure is likely higher.
What of the advisement that, and they can be consecutive, so it's double?
Sure.
Which would have, because the sentence which is imposed is well below what double of what the low end would have been, I think.
I think that's right, Judge Redford. And I think I'll say on that it's different assessments of risk there in terms of those I don't want to say we're talking about apples and oranges, but it's kind of different things.
I always like to say we're talking about apples and rutabagas here.
We'll go with that then. One is, and one, again, we're asking for a Ginther hearing because we like to make a record, but Mr. Keith Young can testify about what he thought when he heard the word consecutive. But I do think those are two different kind of assessments in terms of there's one world in which the courts, a judge or someone hearing from a judge, your range is X, Y, Z. That a judge is more likely, okay, this is my range. I'm probably going to get in that somewhere in that range. And even when the judge or here the prosecutor mentions the word consecutive, that there's a significantly potentially less likelihood that a judge is actually going to impose a consecutive sentence. So I think those are different things in terms of the risk of each one. But what needs to kind of occur is, to the extent the client is going to rely on accurate information, it should be that they understand that the sentencing range is at least accurate or let's say in the ballpark.
Does it matter? This was a blanket denial, wasn't it? Meaning
What was a blanket
the
denial?
defendant's position was, I didn't do any of this stuff, right?
Oh, correct. He maintains his innocence, if that's what the court says.
If that's so, then why does it matter what the plea offer was? Because he's saying, I didn't do this.
Well, I'm sure, as you know, Judge Redford, people who may be innocent or maintain their innocence all the time take deals all the time. It's about risk, right?
When you raise your right hand, you say, do you swear or affirm the evidence you're about to give in this matter now in hearing will be the truth, the whole truth, nothing but the truth, so help you God? I do. What is your name? Bill Jones. You understand you're charged with A, B, and C? Yes, I do. Do you understand here are the rights you're going to give up? And then you ask for the factual basis to give support. And then they say, you're telling me that we should expect that people are going to perjure themselves?
I think the court should expect that when presented with an offer, that a defendant may take that offer, even though they may feel deep down that they're innocent, whatever it is, that they may take that offer. And I think we understand our system. People do that all the time based on risk.
Was there any discussion of a nolo contendere?
I don't recall any discussion of.
Okay, so if it's either, yep, I got to swear under oath pursuant to the possibility of prosecution or perjury that I committed sexual misconduct with my companion's niece, or I'm going to go to trial, and your client has said from day one, I'm going to trial because I didn't do this. Well, I don't know how you get to reinstate the plea agreement after you rejected the plea offer because you said you're innocent, and you go to trial on a jury conviction.
Well, I do think, Your Honor, that this is, essentially Lafler does say you would reinstate the plea, but the point here is that as supported as borne out by Mr. Keith Young's offer of proof, he's saying he would have taken this plea had he understood what his exposure was in terms of this being only an estimate. And that was not explained clearly to him. It was not explained.
What? Sorry?
An estimate. It was not explained clearly to him. And that's really the issue here. This is where it's a very precise moment in time where the deficient performance at the basis for this ineffective assistance to counsel claim occurs. When the court and the prosecutor tell Mr. Keith Young, your exposure is 78 to 162 months. At that moment in time, it was incumbent upon trial counsel to pull his client to the side and say, hey, I know the judge, I know we trust the judge. They told you this. I don't think that might be right. I think your exposure is higher. And I need you to understand that was just an estimate and that your exposure is higher. And then we have to remember a lot of the people that public defenders represent, Mr. Keith Young here in particular, are not sophisticated people. So when your honors hear the word potentially, or you have the ability to really understand what that means. Someone like Mr. Keith Young doesn't until someone pulls him aside and explains that more thoroughly to him. And that's really what trial counsel needed to do.
Do you not understand what consecutive meant either?
I mean, again, that is something that we would like to put, if we have a remand for an evidentiary hearing, I'm sure Mr. Keith Young will testify about that. But again, the question is, what was trial counsel's duty in terms of when these statements were received from the court in terms of advising his client? And Mr. Keith Young, as supported by his proffer of proof, was not adequately advised that that was just an estimate, that it was low, that his exposure is much greater. If there's no other questions from the court, I'd say consistent with Lafler, Mr. Keith Young asked that this court to find that he was deprived of his right to effective assistance of counsel, and to the extent more record development is needed, there was no Ginther in this case, and so we're asking for a remand for a Ginther hearing so that anything, we can determine exactly what, if anything, and I don't think there was anything said by trial counsel to Mr. Keith Young at this juncture when the court gave these ranges, which weren't the most accurate.
All right. Thank you. Mr. Judge Walls? Okay. Judge Levinci?
You covered all my questions, Judge Redford. Thank you.
Thank you. All right. You have time for rebuttal. Thanks, counsel. Nice to see you as always.
Good morning, Your Honors.
Good morning. Let me have just a moment.
Oh, absolutely.
I want to not be dilatory in my duties to my colleagues or to the litigants.
It's on me. I jumped the gun, Your Honor.
Pardon me?
I jumped the gun, Your
No,
Honor.
no,
Just
no.
too
it's-
anxious. to
Appreciate
come
your
up here.
enthusiasm. So, okay. You may proceed, counsel.
All right, great. Good morning, Your Honors. Katie Went with the Kent County Prosecutor's Office on behalf of the people. I will also focus on the first argument, given that that's what the defense has focused on today. But of course, I too welcome any questions on the other two. And I guess before I start on the first issue, I would direct this court, as Judge Redford has already mentioned today, to People v. Shannon, an opinion that Judge Redford was on for the cruel or unusual punishment. I did not file a supplemental authority, but I think that that is very persuasive as it relates to the CSC 3 claim here and the SORA issue. Also, Cardaz has come out since we did our briefing as well. I think those two foreclose that argument completely. With respect to the ineffective assistance of counsel claim, Your Honors, there's no magic words that a court must use to tell a defendant that this was an estimate. I'm sure Judge Redford, in your time as a trial attorney, you might have used different words than Judge Noto did here, but I believe it was effectively communicated based on the overall context of this dialogue that this was not a guarantee for.
Was there any no contendere discussion?
Not that I'm aware of, Your Honor.
I didn't see anything in the
I
record.
didn't see anything in the record either.
It was, what's your understanding? Did the defendant, from the moment the case started until this very day, has maintained his innocence?
I believe so, Your Honor. I looked back at the PSI yesterday in preparation to see if he made a statement about this claim, because often we do have a statement there maintaining innocence, and he declined to make a statement for the PSI, which is his right to do. But my understanding throughout the course of this is that his defense has been, I didn't do it, which I do believe will go to the prejudice analysis of this ineffective assistance claim, if the court wants to skip ahead to that, like Strickland allows it to do. But as it relates to the record that we have, from the very beginning, Ms. Bartlett put on the record that the plea offer was capping the sentence at the properly scored guidelines. She did not provide a guidelines range there because she couldn't. That's what MDOC would do. And then the Judge Noto asked, does she have an idea of what she expects those to be? She talked about her personal calculations. And then, of course, as we've discussed already today, Judge Noto said, do you understand that potentially your guidelines are looking at the 78 to 162. I don't believe that potentially is legal jargon. I don't believe that that's a word that, we as lawyers understand, but we wouldn't expect someone out on the street, a layperson, as I'm walking back and I say the word potentially to somebody, I don't think that they would misunderstand what that means. But even so, what I really think is interesting as I was preparing for this, what struck me is the defense has not presented any information to this court of why defense counsel should have actually anticipated this higher guidelines range. As the court knows, you can consider trial testimony, trial evidence, the PSIR when the court is calculating guidelines. There's absolutely no argument that's been presented to the court that said it was unreasonable for defense counsel not to correct the guidelines range that Ms. Bartlett said, or to have calculated them any differently. And what really stands out to me there is that the defense is saying, defendant gives this affidavit that I would have pled guilty if the guidelines were if I knew the guidelines were 99 to 200, if counsel had advised me that that was my sentencing exposure. But the defendant now on appeal says, I don't even believe that guidelines were 99 to 200. They should be 81 to 181. Or I can't remember the exact tab of the guidelines range. But even the defense is now arguing that 99 to 200 isn't the correct range. So I disagree with not only that OV3 argument, but how can we reasonably expect counsel to advise defendant that the guidelines were 99 to 200 if defense doesn't even believe that's the case here today? So I think that we have to look at the time that these guidelines were calculated by the people, the time that that estimate was placed on the record, and ask, was it unreasonable for council to also rely on that number and that estimate at the time? And defense has pointed out nothing to this court, no chart, none of their own calculations of what defense counsel would have known pre-trial to suggest that he would not have calculated the guidelines in the exact same way. Court doesn't have any other questions. I'll rest on my brief for the rest of it.
All right. Thanks.
Thank you, Your Honors.
Thank you. Josh, any questions? All right. Thank you, Ms. Wynn.
Thank you.
Mr. Wright.
I think just 2 points, Your Honors. I believe sister counsel talked about how there's no magic words that the trial court needs to give. And I agree there. Again, this is about what trial counsel should have communicated, not necessarily what the court communicated. It's about the advice trial counsel should have given in that moment. So it's not about magic words from the court. It's about when the court or the prosecutor gives a range, then trial counsel has a duty in that moment in time to explain estimates to his client and to make sure the client understands.
That's only true if, to the extent the trial court or the defense counsel could ascertain that perhaps the trial court or the prosecutor misadvised the client, right? I mean, so I understand you're saying it's not the trial court's job, it's the defense attorney's job, but that sort of assumes that there was a mistake and that the defense counsel knew about it. Otherwise, it's not the attorney's job, defense attorney's job to correct every little issue that might come up.
I'm glad you raised that, Your Honor, because I think it also dovetails with sister counsel's second argument,
right? In
terms of like, even I've calculated a slightly lower, but still
right.
above what the client was advised guideline. And
right.
I did want to address that. It's still that trial counsel has to tell the client that his exposure could be higher. And the reason for that is almost as sister counsel articulated, which is stuff happens at trial. We don't know what the evidence is going to be. It comes in and then things can change, right? So it's incumbent upon trial counsel before going into that situation to tell his client, hey, you just heard this is your range. That might change. That might go higher. I don't know exactly how your trial is going to go. That could go higher. And I need you to understand that you just heard 78 to 162. That could go higher. Your exposure actually could be higher here.
Okay, but hold on. Your client rejected the opportunity to have that discussion. The judge specifically stopped after the judge talked about it potentially being in that range. The judge says, if your client wants additional time to talk to his lawyer about the plea offer, the court will give him additional time. And he rejected that offer. Said no, he didn't want to talk to him.
I agree with you, Judge Wallace. And again, it's incumbent upon trial counsel in advising his unsophisticated client to say, hey, judge, we're just going to take a second and make sure his unsophisticated client understood everything before walking into trial. So just because an unsophisticated, unemployed client says, I think I'm good, it's the lawyer's job to make sure he's actually as good. It's the lawyer's job to make sure he actually understands what he's signing up for. With that, I have no further argument unless there's further questions from the court.
Is the issue then essentially that, we have nothing in the record, though, to suggest that the defense attorney didn't do any of that, right? I mean, you're saying a Ginther hearing could develop what the defendant was thinking, et cetera, but it also could develop that the defense attorney comes in and says, actually, we met 25 times. I told them 25 different, potential guidelines, that's also possible too. That's just why it gets to the Ginther hearing issue that you raise.
Correct. And again, we're asking for that remand for the Ginther. And you're absolutely right, Judge. At a Ginther, defense counsel will testify and he could say, I advised the client of this. I think the question is, what did he advise the client of in that moment?
Right. But I just, but God, I see some of the arguments post Ginther hearing. Oh, but he didn't establish, we can't now we heard earlier, we can't give credibility to a judicial officer's statements in a Ginther hearing. We literally heard that from your office in the previous case. We can't give as much credibility to what the judge said, explaining why they sentenced because it was a year later. I mean, what are we going to say about the lawyer at the Ginther hearing?
I think a couple points. I assume you're referring to the prior argument.
Yes.
I think that was not a Ginther hearing. I think that was just a motion hearing on Beck
But
issue.
if
So I
we're
think
going,
that's,
if you're gonna say the judicial officer's statements a year later are not as credible because we're challenging the sentence, what are you gonna say about defense counsel? What is said about defense counsel testimony in Ginter hearings?
I don't think, I mean, again, these are two different cases.
Right.
I'm not sure it's, in all fairness to Mr. Keith Young, I'm not sure it's fair to take the position from arguing in someone else's case against him. But that being said, I do think the court, as we all do, should take whatever testimony is given. That's going to be the record from the Ginther, and the judge, the trial court judge, and this court, if it comes up, will decide how much to put on that. I mean, I think that's the way the game works, for lack of a better word. So I'm not going
It's
to.
not a game
I
at all.
mean, I'm not going to take the position that when trial counsel goes on the record and testifies, whatever he's going to testify, that shouldn't be believed. And, you know, he's obviously testifying under oath. I'm not going to take that position, Your Honor.
I think your bigger point, which is well taken, is that on page 5 of this transcript, when the court asks the attorney, or I'm sorry, asks the defendant, do you want more time? And the defendant says, no, sir. Counsel should have stepped in and said, actually, Judge, if we could have 5-minute recess, I'd like to discuss this with my client.
Absolutely. And that was the point I was trying to make earlier. Judge
Right.
Wallace.
And I don't want the record to suggest that I'm considering, you know, we just heard an argument, and I'm not assuming facts from another case, arguments from another case. I'm focused on this case to the extent that an appellate tribunal above this court says, oh my gosh, Redford really left the reservation. I'm not trying to do that. I'm not doing that. This case is on its own facts. But hypothetically, what are we, how are we going to evaluate this? And we have this specific transcript. And I agree with Judge Wallace just pointed out. The salient point is, hey, let us have a minute. Give me a minute, Your Honor.
Right. And I agree.
That would certainly have been better. There is no question.
And I agree. It's about that moment in time. And I'm not advocating for any position than this court does routinely, or our trial courts do routinely when they have Ginthers. The testimony will be whatever the testimony be. The record will be whatever it is. And then the court will make a finding. And that's what we're asking for, a more developed record to make a finding on this.
Can I ask this, and this may be better directed at the people. What was the source of the discrepancy? What was scored between pretrial and not that it matters to the outcome of the case, but I'm just curious because it kind of gets to the question before of how should the prosecution and the trial court didn't know, kind of obviously identify the error, to expect the defense attorney to have identified the error. What was the cause of the increase?
I assume
I'm asking you because you're at the podium
Right.
lecture now, but I'm not assuming you're the best person to answer.
I'm not going to have a satisfactory answer for you, Judge. I don't know exactly how the trial prosecutor scored pre-trial because, I don't have a PSIR, let's say from that. I only have the final PSIR as scored by MDOC, so I understood how they got to 99 to 200. And yeah, so, and I only thought one thing was misscored there, which is OV3. With the 99 to 200.
If OV3 were not scored, would it go down to the?
What's the
He's still, it's in the exact range is in the brief. Oh, actually I have it here. If OV3 is not scored, i.e. minus 10 points, then his range would be 84 to 175, which is still again higher than the 78 to 162 that he was told about before going to trial.
And I know it's in the record, obviously. What was the sentence imposed? 168?
What was the
Sentence imposed was 168.
168?
So the 168 would be within the guidelines that you think should have been the correctly scored guidelines. Is that correct?
There's two options.
Is that correct?
That's correct. And
Okay.
again, there's two options here. If you agree that should have been the guidelines, then OV3 is misscored and you should remand for resentencing consistent with OV3 being at 0 points. Does that make sense, Your Honor? Sorry.
It does,
Okay.
and I understand I think that's an alternative form of relief you're seeking
Correct.
as opposed to the outright, reinstatement of the plea agreement. But it does sort of go back to, how do we guidelines or calculations pre-trial are inexact science at best. So, okay. I
And
think I
again, it's
understand your
incumbent
position.
upon the trial attorney to tell his client in that moment, hey, I think you're inexact science at best. I think your exposure could be higher, or it could be higher.
Could be lower.
It could, yeah, but I need you to understand that. I need you to understand that. You just heard a range that could be wrong. I need you to understand the range you just heard from the judge and the prosecutor could be wrong.
All right.
Thank you.
Judge Wallace. Oh, anything else?
Nothing further. Thank you.
Judge Levinci?
No.
Anything else? All right. Thank you. This matter is submitted.
Thank you.
Appreciate it. Okay. Next case is case 20. Can versus State Farm Mutual Automobile Insurance Company. Defendant appellant is represented by Shelby Avery and Nathan Sherbarth, and plaintiff appellee is represented by Racine Miller. Okay.
Good morning, Shelby Avery on behalf of the appellant State Farm. Well, this is certainly an interesting no-fault case, if I do say so myself. But one thing I think that's really important to note, because I know that counsel for appellee noted this in their brief, that there seems to be a dispute as to the material facts. We respectfully disagree. No matter what version of the facts is to be believed, and there have been many versions that have been floated, the fact remains is that plaintiff was injured when a firework was lit and exploded inside his vehicle. There is no dispute. Plaintiff admits as much in their own briefing. So that's not a basis to deny.
If you're not in a moving car and you light a firework, you run away from it, right? Any reasonable person does that. If they light a firework all of a sudden that's out of control, they're going to run away from it, right?
Ideally, yes, yeah.
But the fact that the individual is in a moving car prevents that person from running away from that lit firework. You agree with that?
I would disagree in this situation because he
could jump out the door doing however many miles per hour he's going, right?
He testified that his injury was because he couldn't let go of the firework fast enough. That's separate and distinct from any sort of transportational function of the motor vehicle itself.
Yeah, but we look at the facts of the case. The fact of the case is there's a lit firework all of a sudden that somebody, is approximately close to. And I think we can all agree that in normal circumstances, a person would run away from that. You can't run away from it if you're in a moving vehicle.
Your Honor, I would say, though, that there's the Yost case where they said that the situation was just as likely to occur on a couch. If he has a lit firework and the mortar is burning away and it's hot in his hand like he described, even if he's on a couch, the same situation could happen. It's not the vehicle, the moving vehicle that's the issue. It's the fact that he has a fast burning firework that he can't figure out how to get rid of fast enough.
And if you were on a couch and you had a lit mortar next to you, you'd jump off the couch, would you not? Or would you just sit there next to it and say, wow, this is going to hurt?
Isn't the other issue, though, too, the extent to which the navigating the automobile sort of the fact is that he was driving and the car was moving, which kind of led up to however the firework got lit, right? Whether he hit a curb or hit the bump in the road or whatever. And that also, it was the cigarette lighter. It wasn't like he used his own lighter. It was the cigarette lighter of the car, which I understand is not necessary for the car to operate, but it is part of kind of like the function. Like you use a cigarette lighter while driving a car, right? That's not a tangential activity while driving. So
perhaps to light a cigarette, but not to light a firework.
But didn't he say there is conflicting evidence of record? And one of the statements of record by the plaintiff is the cigarette lighter fell on the floor and I was trying to pick it up. And that's when the mortar shell lit. Am I not remembering the record correctly?
Let me just refresh because there were so many different versions. At trial, so the last testimony at trial was that he
had the cigarette in his mouth and he lit it with the car lighter.
Right.
He hit a rumble strip and it dropped. And then he said that it sort of magically turned and turned and turned and then landed perfectly in
Whether
the console.
counsel, it was magic or it was the facts that took place, there's evidence of record that that the fact finder, if they give weight and credibility to that testimony, he's operating the car hits rumble strips because he takes a smoke and he's lighting it. Oh, I didn't. And then the cigarette lighter drops out of his hands. The mortar ignites. He loses one hand and multiple fingers in the other hand when the mortar blows up. Up to the jury to decide whether that's true or not.
As far as the credibility issue, yes, but our position is that it never should have gotten to the jury because both the motion for summary disposition and the motion for directed verdict were improperly denied. We have to look here to the instrumentality. There has to be a foreseeably identifiable use of a motor vehicle as a motor vehicle. Our position is that lighting a firework and having a lit firework is not a.
But his testimony is, I didn't light the firework. His testimony is, I'm lighting a smoke, which manufacturers of automobiles apparently think is reasonably foreseeable because they installed it in the original equipment of the device, right?
Correct, yes.
Lighting a smoke, hit a rumble strip, cigarette lighter drops, it ignites the thing.
And that's where the foreseeability ends.
Where?
Where it lights a firework, because it wouldn't be foreseeable. I certainly agree with the position that the auto manufacturers anticipated that'd be foreseeable that somebody was going to light a cigarette with a cigarette lighter. But the sequence of events that happened here is not foreseeable with the identifiable use of a motor vehicle as a motor vehicle. And that's really the crux here of.
It feels like you're really trying to you're trying to create a situation where the causation issue in a no-fault case is proximate cause, but we know that it's not. It's did the injury arise out of the use of a motor vehicle as a motor vehicle?
Ownership, operation, or use of a motor vehicle as a motor vehicle.
Yes.
Not proximate cause.
Yes, and the arising out of standard here is that it has to be more than incidental, fortuitous, or but for. The vehicle can't be just the situs of the injury, and it has to be used for its transportational purposes. So if we're considering all of those statements of law in conjunction, then here, yes, the vehicle was the situs of the injury, but we know that's not enough. And
Well, isn't the next connection then? Because the guy's in the moving vehicle, he can't run away from the firework, and then so he suffers catastrophic injuries as a result.
Your Honor, I think that the Sixth Circuit has already considered this.
Well, we're not in the
Sixth
I
Circuit.
understand.
That's
I
across the
understand.
street.
I
That's
understand.
110 Michigan. And they're really great judges
Yeah,
over
they're
there,
awesome.
but they're not precedential. They may be persuasive, but
Yes.
and they are
I,
awesome.
I understand that, but they did employ.
He just came from the Fed, so he might want to hear it. And I left the Feds in May 8th, 1998. So
And I do appreciate that it's not precedential authority, but it is, as you acknowledge, it is persuasive. And in Richland Knox, the Sixth Circuit did examine Michigan law and an almost identical fact pattern, actually. A fireworks lit inside a vehicle, the person goes to try to throw it out the window, they can't get out in time, and an injury occurs. And the Sixth
but in
Circuit.
that one, didn't the person intentionally light the firework?
Your Honor, I don't have the case in front of me, and I apologize, I don't recall. But again, in whether or not it's intentional, I think is irrelevant here. We have a lit firework.
I guess that's where yours and my assessment of the facts probably diverge. Because if the respectfully, if you don't have evidence, if the plaintiff doesn't have evidence of a witness saying, I'm driving my vehicle, I fire up smoke, I hit the rumble strips, and then then the thing drops. If he didn't drop, if the cigarette lighter doesn't drop after he experiences the rumble strips, I think you've got a very persuasive argument. I think because the cigarette lighter, which ignites the fuse, which detonates the device, which removes one hand and several digits of the other hand, it happens after the rumble strip hits the tires, which are attached to the vehicle, which is moving down a traveled roadway. I just think it becomes a factual question.
Your Honor, I think there's also a public policy concern that needs to be considered here, that the no.
I thought we were the judiciary. I thought the public policy department was
I
the
understand.
legislature. Is that?
But we do have to consider the legislative intent here. And the legislative intent behind the No Fault Act is to protect individuals who have
I
been.
found liability, or I denied a no cause motion for directed verdict way back in the day when a plane hit a car. And I got teased about it for the next 12 years. But, you know, I think I got upheld. So.
But we have to consider who.
Just kind of ironic that, I mean, you represent State Farm in this case, correct?
Yes.
And for probably a good 15 years, State Farm would come into this court, the Michigan Supreme Court, essentially argue that you're not supposed to talk about public policy
Right,
in these courts. And here you are telling us that times have changed, I suppose. And maybe they have.
Your Honor, I can just speak to the facts and the arguments of this case. And we do have to consider the intended beneficiaries of the No Fault Act. And those are individuals who have been injured while using a motor vehicle as a motor vehicle. And a plaintiff is allowed to recover here, that would go against legislative intent.
And this is a first party case, right?
Yes, this is.
Okay. So we're not, okay.
You know, that's a different issue. And I appreciate that. The intent of the No Fault Act, that's a totally different issue, though. That's not necessarily a public policy issue. But go on, I didn't mean to cut you off.
If the legislator intended for the No Fault Act to extend protections of any individuals who suffer any sort of injury while inside of a motor vehicle, and in this case, while improperly handling a exploding firework, then this would actually also, this is where the public policy, I think, concern comes in, is that part of the No Fault Act, the goal of it is to keep costs down to the public. If insurers are required to pay out claims.
It's to keep costs down to prevent litigation. Right? That's the whole point. The whole point is it's a No Fault Act, which means we don't even have to worry about who's at fault. The insurance carrier is going to pay these specific benefits that the person has paid a premium for. That's how it reduces litigation.
But with increased costs becomes increased premiums, which are passed down to the public. So if insurers.
If the legislature wanted the causation element in a no fault case to be proximate cause, wouldn't they have said that?
Yes, Your Honor, and that's not what we're advocating here. We're just advocating.
You kind of were. You talked for a while about foreseeability. What's the touchstone of foreseeability? Proximate cause, right?
But Your Honor, that is the standard that's laid out in Chiamataro, that injury must be foreseeably identifiable with the normal use of the vehicle. And that's why I'm employing that language, because I do understand that foreseeable can be kind of a sticky keyword. But I want to make it clear that I'm quoting the Michigan Court of Appeals case from 1981. And also just briefly to touch on some of the points raised in plaintiff's brief on appeal.
At that point in time, so that's only 8 years after the No Fault Act went into effect. Was there a published opinion at that point in time that had established that you don't have to prove proximate cause in a no fault case? I don't know the answer off the top of my head. Do you?
I don't either. I'm happy to look into it. I can submit a supplemental authority.
But all right. Go
Okay.
ahead.
But the argument as to the invited error, the jury instruction at issue that plaintiff cites in their brief is just an inaccurate recitation of the No Fault Act. The cases that plaintiff cites are factually distinguishable. So we have People versus Jackson, where the defendant argues in favor of this jury instruction, and then on appeal says, well, that jury instruction was an error, but they advocated for the jury instruction. And then People versus Jones, you have the prosecutor inviting error by eliciting improper testimony, and then on appeal claiming that improper testimony deprived them of a fair trial. We're not bringing this appeal based on a jury instruction. We're not contesting whether there was improper testimony. So I just want to make it very clear that the scope of this appeal is different than those other appeals. And additionally, I think it's really important also to distinguish, there was an analogy earlier to a permanently mounted piece of equipment on a vehicle. Plaintiff cites to Drake versus Citizens, where there was a permanently mounted auger that the plaintiff suffered injury as a result of, and the court found that was use of a motor vehicle. And we would agree with that. It's a permanently mounted structure on the vehicle But here, the plaintiff's injuries were not the result of a permanently mounted piece of equipment on the motor vehicle. They were the result of a lit firework. That and that alone was the instrumentality of the injury, regardless of how it was lit, regardless of what, what version of the events were to believe. At the end of the day, he suffered injury because he had a lit firework in his hand. And that alone is the instrumentality of his injuries. It could have happened outside a moving vehicle just as easily as it happened inside the vehicle. And I don't want to keep belaboring the same
I think we
points.
understand the facts.
Okay. If your honors have any additional questions, if not, I will reserve time for rebuttal.
I do not, but you did a nice job on your brief.
Thank you.
Yep. Okay, thank you.
Good to see you.
Morning.
I'd like to first ask if there are any questions about the case. I've heard what the panel has said and you all seem to be very on top of things. Do you have any questions before I say what I'm going to say?
Not me, but thank you. Thanks for
All right.
asking. I always, the young lawyers ask, what should we do? Ask us if we have any questions.
Thank you. I'm not going, excuse me, it's not my intention to rehash the brief. I do want to address a couple of points that Sister Counsel raised, if that's all right with you.
Sure.
Okay, thanks. Excuse me.
Need some wa- Do you want to get some water?
I just did. Thank you
Okay.
so much.
Yep.
I wanted to talk about, I think it was Yost. Maybe it was called York. It was the Y letter case where we're trying to talk about this could have happened anywhere. It was just the situs. This couldn't have happened anywhere because rumble strips don't exist anywhere. And you're not driving a car anywhere.
On cigarette lighters, don't,
Aren't manufactured everywhere, right?
you have a lighter that's butane, you hit it, it ignites the product, you put that back in your pocket. It's just, as opposed to you're trying to put it back in a holder the manufacturer put there. Although, gosh, what was the year of this vehicle? I don't.
Very good
I don't
question.
remember the last one I saw it, and it's irrelevant. But anyway,
I'll keep it short and sweet since you don't have any questions. Essentially, the defendant here is asking that the court find in this case that the cause of plaintiff's injury was an instrumentality wholly unrelated to the transportational function of a motor vehicle. We fought about the jury instruction. We didn't get that transportational magic language in there. What we got was what the jury found and what was reflected in the verdict form. It was arising out of the use of a motor vehicle as a motor vehicle. And I think it's pretty simple. If we want to talk about the case where there were firecrackers in the back seat of a, lit up voluntarily, intentionally by a passenger, he couldn't get that out the window in time, completely factually distinguishable. In this case, we cleared summary disposition. Then we had directed verdict after the evidence was in. Then we had a jury and all the fact finders were consistent. This court can't at this juncture assess credibility, and otherwise I'll stand in my brief unless there's any questions.
Judge, no.
Don't have any.
No questions.
Thank you very much.
Thank you. Vince?
So very brief. I just want to respond to the last point about the Sixth Circuit case. This is not a wholly different fact pattern. Again, we have a lit firework in a car. In fact, it was shocking to me that there was more than one case out there. So imagine my surprise when I came upon Richland Knox to find that apparently this is happening more than you would think. And to the extent that the jury instruction had the arising out of standard, well, that is the proper legal standard. That's not to be disputed. And we are not disputing the jury instruction or that, and we do contest that we somehow invited error by advocating for that jury instruction.
For what it's worth, I don't see, and I could be wrong about this, but I don't see any case that's been issued since the 90s, other than one case that's been overturned that cites to that C. Mataro. So I'm not so sure that the portion that you reference would still be good law in light of subsequent cases that have indicated that that proximate cause is not the right standard. But I guess that's probably an issue for another day because we didn't ask you to to brief that.
I do believe, and I could check my notes to verify, but that case was cited within a different case that is still good law.
Well, there's cases from the 80s, but there's certainly nothing published after November of 1990.
I could just grab my notes if that'd be.
Yeah, go ahead.
Thank you.
One 1992 case that got overturned.
I believe that case, the Chiamatario case, was a citation, and I could be wrong. I don't have it in front of me and I don't want to misrepresent to the court. So I understand. I will look into that.
You know what? I'll tell you what, I didn't do a deep dive on it. So it's quite possible there is some case out there, and we didn't ask you to brief us. So it's really not fair of me to even ask you. So.
I appreciate the questions, and it's good thing to think about. Thank you very much.
See anything? Good.
Yeah.
All right. Thank you. Matter will be
Thank you.
submitted. Appreciate both counsel.
So Ms. Miller and I have now just tied the record for the most number of Clarenceville alumni to ever be in this room. We tied it for the last time we were here together.
Oh, gosh. We were hearing all about Clarenceville yesterday. So, all right. That completes the 10 o'clock docket. I'd like to continue on if that's all right with both judges Wallace.
Yeah.
Levency. Yeah. All right. Next case is case 21, Brooke Kruger versus Trevor John Curler, case 376-973. Ms. Brooke, the appellee, is authorized to appear for 10 minutes, and appellant is represented by attorney Majewicz. Thank you. Okay. Counsel, we're your parents and you may proceed. All right.
Eric Matwisik on behalf of the defendant appellant.
Thank you.
Your Honor, this appeal rises from initial custody determination involving one minor child. We believe that the trial court committed 3 errors requiring reversal and remand. First, the referee improperly determined the established custodial environment, resulting in the application of an incorrect burden of proof. Secondly, the referee relied on an alleged autism diagnosis that was unsupported by competent medical evidence and used that unsupported diagnosis to decide the best interest factors against the defendant appellant. Third, several of the best interest factors findings were against the great weight of the evidence. And I'm going to focus first on the alleged diagnosis of autism. The referee's factor finding rests on medical conclusion that was never established by competent evidence. The referee accepted the child had autism, accepted that treatment was required, accepted that the father was not participating in treatment, and then used those assumptions to award some of the factors to the mother. And under Pennington, the custody findings concerning medical or psychological conditions must be supported by competent evidence in the record. And comparing this case to the Pennington case, this is much more egregious than a Pennington case, because in this case, in the Pennington case, there was no qualified medical witness, no competent medical foundation, and the conclusions adopted by the court in that case were unsupported. In this case, what evidence existed about autism? The mother testified the child was diagnosed with autism. That's it. That's all we had. That speculative statement, diagnosed with autism. There was no psychiatrist, no psychologist, no physician, no medical records offered, no diagnostic reports, no treatment records, no expert testimony, no testimony regarding the severity of this alleged autism, no testimony regarding a treatment plan for this young boy, no testimony regarding.
Was all of that required? I mean, I guess I take issue with a couple of your arguments here, but ultimately, I mean, didn't your client in some respects, at least at some point, elicit the testimony about autism?
elicit the testimony about autism, being on the record?
Correct.
From,
You fault essentially plaintiff for this, but I think it was actually during some of your clients, your client elicited, again, whether it was by counsel on cross-examination. I mean, again, it can come up with a couple different ways that could happen.
I don't believe my client ever acquiesced that his son had autism.
That's not what I asked.
Oh, okay. Go ahead.
Did your client or your clients, the defendant collectively affirmatively elicit any evidence related to possible autism?
I don't believe so.
All right. I think the record suggests otherwise, but I think the other part of it is that I understand that, autism was just one of many factors under the best interest factors, right? I mean, is your position that if all of the evidence of autism is excluded, that the whole outcome goes a different way?
Well, yes, absolutely. This referee demeanor, what can be shown from the transcript certainly, really was used that against my client, especially when the statement was made. The child has been diagnosed with autism, and the appellant's only contribution to the support and treatment of the diagnosis is to passively deny that it's accurate. And that was in the recommendation, initial recommendation. It's the attitude of the referee, as can be gleaned from the transcript.
And that was a
Did not care for my client.
That was a 6 to 7 page single spaced paragraph document, and that's the one sentence, right?
Right.
That's, I guess that's, we have a difference of opinion as to the appropriateness of the testimony and who elicited it, but I'm kind of moving on to the next, which is, okay, say you're right, that it's not that the autism permeated all of the best interest factors, at least in my read.
I think it clouded her judgment when she analyzed the best interest factors, certainly just by the attitude of the referee holding it against my client, because she believed, no question, that this child had autism, and my client the defendant appellant was not doing anything about it, which is absolutely his testimony. He didn't believe that his child had any issues. But the question is, I think that in the elicited testimony I think at one point, there was testimony from the referee stated that even the boyfriend said he had autism. So now we had the boyfriend, we have the mother talking about this diagnosis of autism, which again, you can't cross-examine something that's not there. And there was no medical expert there, meaning
I believe your client testified that the kid had strep throat at some point, but he's not a doctor.
I think so.
Okay.
But again, looking at this case, from a Pennington standpoint, it's our opinion, and it has to be remanded back for an evidentiary hearing. It's just no question about it.
I get it. Like you said, it sort of clouded the proceedings is your position.
Oh, absolutely.
Okay.
Absolutely. And I think that's the lack of competent evidence supporting her finding. And I think going through the transcript, autism's mentioned, 32 plus times in that transcript. And once the referee allowed that testimony, the plaintiff's counsel just beat it down with every question almost about this diagnosis of autism. And that I think clouded the record. And I think that just got the referee clouded as well. And I think that she held that against the appellant during the proceedings. I think it's just, when you look at the Pennington case, it's much more egregious than Pennington. Any more questions? No.
Even see, I do have a question, and this is a clarification. It looks like appellant's exhibit 1 is the amended stipulation regarding parenting time. And there's just sort of a discrepancy in the record, or maybe I'm misreading it, that the amended stipulation was dated December 12th of 2024. But it appears as though there had been some sort of parenting time agreement in place before that. Is that in the record at all?
I think it was, but that was a result of my client having to decide if he wants parenting time, even on a limited basis. I think that's how that came about.
I understand your argument about whether he agreed to the stipulation voluntarily or not. That's not what I'm asking. I'm asking about before this stipulation. Where's the evidence of what parenting time agreement existed? I just didn't see anything in the record. Clearly there was something. I just don't.
I have to refer to the record, but I think that the parenting time was cold turkey once the mother moved away and did not give parenting time, and they had enjoyed 50-50 up to that point.
When was that?
That's, I think for 18 months, they enjoyed 50-50.
And that's what I'm asking. Is that anywhere in the record?
Oh, that's in the record.
Is that the amended order? Amended stipulation, rather? I guess you have an opportunity for rebuttal. I guess just it's a clarification in the record. There's a December of 2024 or amended stipulation with an attached order regarding parenting time. It's your Exhibit 1. And I'm just wondering what governed the parenting time situation before that amended stipulation.
I don't think there was no order in place.
There was no written, it was just informal. There's no written. Okay, that's fine. That's my confusion. Thank you.
Thank you.
All right. Thank you, counsel. All right, ma'am, you've made a motion to appear and you're authorized 10 minutes of discussion. If you like, if you could approach the podium, indicate your name, we'd be happy to listen.
Good morning, Your Honors.
Morning.
I'm extremely nervous, but we're gonna get through this. So my name is Brooke Kruger. I am mom. I want to start.
Well, the one thing I didn't say, if we could refer to minors by their initials, that would be great.
Oh, okay. Yes, absolutely. Would you like me to just address him as a
please go ahead.
child?
Child is fine.
Okay. So, first I want to start out by asking the court to dismiss this case based off of lack of jurisdiction for untimely file. When this court order was put in, it was put in on April 14th, giving them 21 days to file an appeal. That means that the deadline would have been on May 5th of 2025. We never got the actual order until May 21st, which would have been 37 days after the deadline. And then so that appeal was dismissed. Now we are coming to the the leave of appeal, which was entered in on August 21st, so 92 days after the first appeal was denied. So I'm asking for this case to be completely dismissed.
This court already granted leave to appeal, didn't we?
Yeah.
I think Judges Boonstra, Schwartzel, and Yates were asked, they were the motion panel, they granted leave. So that issue's already, and you didn't ask for a motion for reconsideration for that decision. So we're beyond that.
Okay. So then I would like to go into the stability thing. So when it comes to the minor child, I have had the minor child in my care since July of 2024. So roughly a month after the diagnosis of his autism, which I didn't know that I needed in court. I wasn't told by my attorney that I needed that, or it would have been provided. So for nearly 2 years, I have been my son's primary caregiver, primary financial provider, and the parent responsible for daily care, education, medical treatments, things of such. The referee specifically found that I provided the more stable environment for our minor child, as the appellant did inform during court that he was in between his mother's house and his girlfriend's house. When it comes to medical decisions and, you know, the evidence brought to court, the appellant did also inform the referee that he left medical decisions up to me primarily. I did inform him where he could obtain the autism diagnosis, and it has continued still to this day to not be retained. So I do believe that continuing on that for the minor child, the best interest factors, if stability, would be to keep the court order the way that it is. I believe that the structure and making sure that everything is stable for him and routine is very, very important. I don't really know what else to say. But when it comes to my son, he is very, very structured with routine and knows kind of how his day-to-day works. He knows that on Wednesdays he goes to his father's. He knows that every other weekend he goes to his father's. The exhibit 1 that Judge Andrew had brought up actually was signed by me on 11/11 of 2024, I believe, and then signed by the appellant on 12 of 2024. So we had never received that until we were actually in court, and that's where it was supposed to be that the appellant only got Wednesdays from after school until 7 o'clock at night. I'm the one that made the decision to let him have the overnight to where he brings, the minor child to school on Thursday morning. So it's not that I don't want the father to have time, it's I want the minor child to have structure. That's it.
Question for you. Has a child ever been diagnosed by a psychiatrist or a psychologist?
Yes, I do have that paperwork here with us
No, I'm
today
not-
too.
You don't have to give us paperwork. I'm just asking. So, because the thing that you attached to your brief was signed by a master social worker, licensed master social worker. So that's not what I'm talking about. I'm talking about a psychologist or a psychiatrist.
Oh, I'm not quite sure. That's who diagnosed him, was the lady that wrote that out. That was who we were recommended to go to. So I'm not quite sure
Understood.
if there was something else there.
I have a quick question. The same question I had before. Was there any sort of written parenting time agreement before that document we talked about?
There was nothing written. Me and the appellant did have a verbal agreement.
Okay.
Um,
And then is this still the parenting time situation that's described here?
The one that is court ordered currently is the parenting agreement. So every Wednesday and every other weekend.
The one from December of 2024?
Yes, I do believe nothing has changed.
Okay. And I guess okay, because we're here essentially reviewing the appeal and the record as it existed at the time of the appeal. We don't know, and anything that happened since then, we don't know, and that's not
Yes.
part of our consideration, but I just wanted to clarify
So
the chronology of the parenting time situation. So
yeah,
thank
so
you.
as of April, I don't think anything changed from December to April's parenting time. So as of the April final order, that is, I know for a fact how parenting time has been shared.
Okay, thank you.
How old is the child now?
He is 6. He will be 7 in July.
Other questions?
No question.
That's,
I don't.
all right, thank you.
Thank you.
Thank you.
Okay, counsel, any rebuttal?
Briefly, Your Honors, I hope the court's not considering that exhibit that was attached, that wasn't part of the record. I just want to make sure I get that clear in my head. Again, I'll just reiterate that this is not merely an evidentiary issue in this case. It's lack of competent evidence to support any type of diagnostic or diagnosis of this young boy.
Well, have you looked into the issue of whether, forget about the exhibit itself. Have you looked into the issue of whether a LMSW is even qualified to?
Of what?
Have you looked into the issue of whether a licensed master social worker is even authorized under Michigan law to diagnose?
I have not looked at that. To me, that wasn't part of this appeal, but certainly I think in this case, it's going to come down. We're going to have to look at that, certainly. But that on the record, again, there's just statements with no supporting evidence made by the plaintiff and the witnesses. And again, in Pennington, I think it's really instructive for this court. In that court, they rejected custody findings based upon unsupported medical and psychological conclusions where no competent medical evidence supported the findings. And evidence that was presented, I wouldn't call it evidence, most of it was, all of it was hearsay, but again, it's not competent evidence. So it goes beyond just an evidentiary issue. And the referee then accepted that existence of the medical diagnosis and relied upon that diagnosis to conclude that the appellant was not adequately taking care of his son or addressing that treatment. And that just is out there. So no competent evidence establishing, again, I'll just reiterate, no diagnosis, who made it, qualifications, severity, treatment, father's alleged refusal to participate. And so that equals a lack of competent evidence. And again, I think that flavored the referee and analyzing the best interest factors. I think she misapplied the custodial environment. Certainly it existed with both parents. Even the referee even made that comment that in her decision in the recommended order that there is a custodial environment with the mother, with the plaintiff mother, and somewhat with the father. And when you say somewhat with the father, that to me, that equals there is a custodial environment based on the evidence of the record that a custodial environment existed with both parents. And she misapplied that. And I think third, that again, those best interest factors were against a great weight of the evidence. And I would ask the court to vacate the custody order and remand it back to reconsideration under the proper legal standards. Thank you so much. Any questions?
Yeah, forgive me because I think I know the answer to this, but I don't want to guess. So what is the legal custody situation again as it stands? Not the parenting time, but the legal custody.
It was joint legal custody.
Okay. So with joint legal custody, has your client ever had the child examined by a psychiatrist or a psychologist?
I post after the hearing.
Ever?
I'd have to ask the appellant.
You don't know. It's fine to tell us you don't know.
But
is that you don't know?
I think his testimony during the hearing was his child gets along great in the home and there is no evidence of anything that was wrong with him.
Okay, let me ask this again. And if the answer is I don't know, then please tell us I don't know. If it's attorney-client privilege, say I can't tell you that because it's attorney-client privilege. Has your client ever had the child examined by a psychiatrist or psychologist?
I don't know the answer to that.
Okay, thank you.
Specifically, I don't want to say yes or no if I don't know.
That's all
the
I
answer.
want.
And
any other questions?
Is there a determination of whether or not there is an existing custodial environment with both parents?
Is there a what?
Existing custodial environment with both parents.
Oh, for sure. I think the record showed that.
And it is what?
My client testified that they had been together 18 months. He took care of the child almost all the time when the mother was out partying. I think that was the testimony, but he was the main caregiver. And his mother supported that too at the hearing.
I think what Judge Redford's asking is the conclusion by the trial court was that both parents had an established custodial relationship environment, correct?
She said somewhat. Right.
So yes. I know this says somewhat, but somewhat, or, I mean, because it impacts the legal
Yeah,
standard.
is there, as we stand here today, my understanding is there is an established custodial environment with both parents. Is that a correct or incorrect understanding of what the status of the case is?
Well, I would have to, well, Your Honor, that's a tough question to answer because the referee said it's somewhat so the answer would be yes, because she said somewhat.
Okay, so yes, is the answer, right?
Yes.
Okay, and that there is is there or is there not joint legal custody?
Yes.
Okay, that's my understanding of the of things as well. I was just a little. Okay, so, all right, thank you for those
Thank you.
responses. Anything else from either judge?
No, thank you, though.
No. All right, the matter is submitted. Thank you. All right, court calls final two cases on the court's docket for the June case call. Case 22-376-131, In re P. Copa Minor. The matter is submitted without oral argument. Case number 23, case 378-131, Cassandra Dawn Rock versus Dominic William Rock. Case is submitted. There's no oral argument for that matter either. That completes the court's oral argument in panel 6. Thank you. Court is in recess.